Okay, we're going to try this to see if we can get the recording initiated. Again, welcome to the lecture. This is for Chapter 16 in the textbook. The PowerPoints are available under the course materials section in Blackboard. I would suggest that you print those off and take notes as we go through so that you can study effectively. Chapter 16 is based upon the ethics and the standards of professional conduct that are put forth by the CFP board, and they're testable material for the CFP board exam, and they frame the basics for the fundamentals. The fundamental ethics and principles of the CFP board, to use the Certified Financial Planner, the rules by which the Certified Financial Planner certificates are judged. So it's an important set of rules, and I'll show you as we go through this chapter where you can find that information. So here's how the chapter is broken down. The Code of Ethics and Professional Responsibility, typically just known as the Code of Ethics. Then we'll get into the rules of conduct, the practice standards. The disciplinary rules are basically if you do something wrong, what the CFP board can do to you. And then candidate fitness standards. What your background and track record, personal background and track record can be if you're going to hold yourself out as a certified financial planner. So the CFP board does background checks. So we'll go through the list of things. Those last two pieces are fairly short. It's the first three that are fairly lengthy, and that we're going to spend the most amount of our time on. So again, the CFP board, it's important, particularly for public trust, that the CFP board holds to a high standard of not only competence, which is why you're going through all these classes to learn what you need to learn, but of ethics. Clients must know that somebody that holds the CFP mark has an oath, just like people have heard of the Hippocratic Oath that doctors take to do what's financial planners have to do what's in the best interest of their clients. So that's something that's important to maintain the public trust. Again, just a graphical representation of how this chapter's laid out. The 7 principles are integrity, objectivity, competence, fairness, confidentiality, professionalism, and diligence. And these are the fundamental, these are the things that make up the Code of Ethics of the CFP board. So you can see, you can read paragraphs on each one of these principles: integrity, objectivity, competence, fairness, confidentiality, professionalism, and diligence. I remember these by International Olympic Committee, Fulton County Police Department. However you remember them is fine. I will ask that you memorize these 7 principles. This will probably be the second question on your exam, is whether you can identify the 7 principles that make up the Code of Ethics. So here's a little bit as we get into each one of these. So integrity is just about being honest and doing what doing what is in the best interest of our client, regardless of how we might fare personally, depending upon what the client does. Objectivity implies impartiality. It means that I look as a third-party, uninterested outsider, think that this is what you should do. And so it's difficult, I think, for people to often serve as their own, even financial planners, to do their own financial planning, because objectivity is difficult, particularly when we get into some personal issues and desires. Subjectivity creeps into it a little bit. So it's important to protect the integrity of the work, to maintain the objectivity, and it can be a slippery slope when it comes to subordinating your judgment. Competence. This is why we have education requirements and continuing education requirements for certified financial planner certificates. Fairness, it's hard to distinguish what, the difference between objectivity and fairness. Fairness really has to do with how you treat someone, how you treat a person. One of the things is that you have to disclose potential conflicts of interest, things that could be potentially viewed as conflicts of interest, not just things that you think are that necessarily are conflicts of interest. And so you should avoid conflicts of interest when you can, and when you cannot, conflicts of interest must be resolved in favor of the client always, because we have to put our client's best interest first. Confidentiality, that is pretty straightforward, that we can't share client information. We can't even tell someone, oh, that person's one of our clients, unless that client has given us express permission to do so, and it should be written permission if you want to CYA. Professionalism, and this is kind of a nebulous term. Professionalism means to act in a manner that demonstrates exemplary professional conduct. So that's what the definition of professionalism is: behave professionally. So some examples of that is cooperating with other people, acting in a dignified and professional way, doing what you say you're going to do, coordinating with other professionals and treating them in a courteous manner. Those are things that are the marks of a professional. Diligence means that you're going to consistently follow up and do the things that you say you're going to do in a reasonably prompt and thorough manner. You have to be diligent in all things that you do in terms of gathering information, following up to make sure that you have everything, making sure that there are no holes missing, diligent in your communication with your clients, making sure that they understand everything that they need to understand, and following up with them and documenting those things, diligent in the record keeping that you do. So diligence goes across a broad number of areas that is financial planning. So all these things are the code of ethics that a financial planner is held to when they are engaged in financial planning. So it's important then that we define what is and what is not a financial planning engagement. So if I'm doing something, not necessarily everything that a financial planner does for someone that a CFP certificate does for someone that may involve anything financial is necessarily rises to the level of financial planning. So this phrase is an important one, providing the material elements of the financial planning process. So if you're following parts of those 6 steps of the financial planning process, mutually establishing the relationship, gathering data, analyzing that data, coming up with a set of recommendations, and then agreeing upon implementation of those recommendations and monitoring responsibilities. If you're doing that, that's clearly financial planning. But how else can we look at that and say what rises to the level of financial planning? Well, we're going to look at four areas. So the client's understanding and intent in engaging the certificant. That is, it's hard if you're sued and you say, well, what I was doing was not financial planning, so I should not be held to these standards. And they say, well, the client says, well, I thought so. Then, oh, well, it's hard to prove what another person thought. That's why it's important when you do something for someone to define the engagement in writing. So but most of the time that we define the engagement, it does rise to the level of financial planning. So that can be kind of a sticky situation. What we'll kind of figure out as we go through this is there's relatively very little that a financial planner does for a client that will not rise to the level of financial planning. A one-off sort of, here's a general piece of guidance or advice that is outside of something that a financial planner normally does, and it's for somebody that's not an ongoing client, that may be not considered financial planning. But we'll see as we go through this what rises to the level. The degree to which multiple financial planning subjects are involved, generally 2 or more. Now, what we can say is, and lots of people who give investment advice or advise on investments in the broad sense, and I say in the broad sense because there are 2 different sets of rules for which investments are governed. People operate under a license that would be, let's say, a general securities license under this known as the Series 7 under FINRA, or under the Series 65 of the Series 65 Act, which is the Investment Advisory Act, which is an act of 1940, and there's a fiduciary standard that's applied for those who are providing advice under the Act of 1940, but the fiduciary standard is not applied under the Act of 34, which is what governs the Series 7, which is more of an arm's length, buyer beware sort of language that the standard is applied. It's known as a suitability standard. So, digressing a little bit there, I'm primarily focusing on, if we were just going to do one area, lots of times that particular area would be advice or insurance that people hold themselves out. That's all we do. We don't do necessarily financial planning. Can a CFP say that I only do one of those areas? I think what we'll see here is that looking at this on the surface, technically yes, but I think once we drill down further, that's going to be hard. That's going to be hard to prove. The comprehensiveness of the data gathering, if you ask questions across more than one area, then the implication is that the advice is going to be given across more than one area, and therefore the standard of financial planning applies. And then the breadth and depth of the recommendations is certainly, will be looked at. So, examples of activities that may be considered of financial planning: detailed data gathering across multiple aspects of a client's financial situation. So if I'm gathering data and I say, oh, someone's just coming to me for investment advice, how do I give advice without being comprehensive? I should figure out what are their objectives, and everyone invests with an objective to make money, but I need to know a client's time horizon, which might imply some sort of goals. So I might need to know what the client's goals are. Once I get into that level of figuring out what the client's goals, the purposes for that investing are, what's this money for, in other words, then I think I've crossed into the level of what financial planning is. But I don't think I can give good investment advice without understanding what the money is for. I don't think I can give good investment advice and assume that a client should be investing for the long term unless I figure out that this is certainly long-term money. To know this is long-term money, I have to know that my client's emergency needs are taken care of. That's getting into risk management. That's getting into cash management. If I need to know that their short-term needs are taken care of, that's generally a multiple of what their monthly expenses are. Now I'm looking at some things that are in their budgeting. So so once I get into those things, it's hard to open up without doing a can of worms. And I don't think you can provide good advice in one area as a standalone thing at all. I think good advice by its nature must be comprehensive. So providing investment advisory services as defined by the SEC. Well, how does the SEC define investment advisory services? The SEC, let's look here at Rule 13. This is the Investment Advisors Act of 1940. Investment advisory services means giving continuous advice as to the investment of funds on the basis of the individual needs of each client. Well, I don't know how you provide, I guess if you're just giving a tip at a cocktail party, then that might not rise to the level of financial planning. But I don't know how, if I've got an ongoing client, how, even if I'm just holding myself out as an investments person, how I can not be held to this definition, which means that I am necessarily providing investment advisory services under the SEC, which means that that is held to the level of, rises to the level of financial planning. And then under the Investment Advisors Act, there's certain written information in of disclosures that have to go out, just like under the CFP board when you're doing things that rise to the level of financial planning. What might not be financial planning? A broker opening paperwork to complete an account. Yes, but to completing paperwork to open an account. Yes, but then how is that money going to be invested? A broker acting as an order taker for brokerage services. If you're just investing money and all I'm doing is taking your orders and placing transactions in the market, then that is not investment advice. But once you ask me what I think that you should do, or you bounce particular ideas off of me, I have to think, well, is this a good idea? I have to then say, well, is there something better that you could be doing? And then that gets into providing investment advice. So I think the way that the rules are written, not necessarily the way that things are that the brokerage industry, broker-dealers try to conduct themselves, but the way the rules are written, it's clear to me that investment advice is necessarily has to do with financial planning. Someone acting as a mortgage broker without providing any other financial services, clearly that wouldn't be investment advice. A CPA that just does tax preparation without doing any other financial services is not financial planning. But about a third of CPA firms are also in the financial planning business, by the way. And then what I'm doing in this class is not providing is not providing financial planning to you, my students. So moving on, so now we're going to the next section. What are the rules of conduct? The rules of conduct are there to establish high standards for professionalism. That's the rules. But here's how they're organized. It's basically about defining the relationship, information, and obligation. So you can think of RIO, relationship. So mutually defining the relationship. Information, we have to think about those two things. Information has to be disclosed. That's pertinent information that the client should know. And then I have to protect the client's information that the client gives me, because I have to gather information from my client in order to provide proper advice. I then have to protect that information. And so there are rules about how that information would be protected. And then obligations. I have obligations to 3 different parties: my clients and prospective clients, employers, and to the CFP board. And so We'll get this slide. I believe it's slide 32, and that's a good study slide because it lays out the obligations. So, in defining the relationship, generally this will be done. We want this to be done in writing, and we'll say the obligations. We'll talk about how we're going to move the terms of the engagement through each step of the process, how we're going to gather data and find goals. We're going to talk about what analysis will be run, how we're going to so examining the results of the current course of action without changes. So that's analyzing where you are currently and what the implications of that are. Then we come up with a formulation of recommendations, and we need to talk about that. So there's all sorts of disclosures that need to be done about that, because those are based often on projections about things in the future which are necessarily uncertain because we don't have any crystal balls. And then there are, in the engagement, we should talk about who's responsible for implementing. And often there's almost in practice, there's a financial plan, and then there's a plan to implement the plan. And that's not necessarily done overnight. That's done over a period of time, and things need to be tracked, and there needs to be a primary person responsible and dates for each steps of implementation. So that needs to be clearly, that the implementation is a process that needs to be managed and documented. And then monitoring responsibilities. We need to let our clients know that when they have a material change, a change that will affect their financial situation, if they lose a job, if they get a significant raise, if they get an inheritance, if they get a judgment against them in a court of law and are required to pay, anything. If there's a marriage, birth, death, anything like that that's a life-changing thing, clients have to let us know, because that's part of the responsibility. Then we have the responsibility for adapting the financial plan. So that's part of monitoring, but that's client responsibility to let us know when something needs to be tweaked based upon their personal changes to their situation. We definitely need to be very clear about how we are compensated and how much and at what times. Terms under which either party can terminate the relationship, and then how other entities may be involved, and the rules under which they may be involved, the parameters going forward. For example, I may need to share some information with an attorney that's drafting estate documents. I would need to get explicit permission, preferably written, from my client in order to share that information. But it would be clear, and it would be part of my engagement that said, I will only share this information as directed by the client, and only to the extent that the sharing of the information helps that other entity, here in this case the attorney, in completing the estate plan of the client. So I wouldn't need to share any information about investment risk tolerance, for example, then with the attorney. So here the agreement should specify who are the parties to the agreement, the date of the agreement, and its duration. And often there's an initial engagement, which is for the financial plan, and that might take some period of time. And then there's an ongoing agreement if the client decides to hire us for implementation in future financial planning and management. And then what specific services are going to be provided as part of the agreement. Here, in case it wasn't said so earlier, a certificate shall at all times place the interest of the client ahead of his or her own. certificate can't lie. You can't or mislead the client, and you should disclose in writing a description of how you're going to be compensated, including maybe not directly by the client. If you are compensated by a product salesperson, you need to disclose that. And it needs to be accurate and clearly understandable. So often you'll see that some financial services firms, insurance companies, for example, sort of have a black eye that's fairly well deserved because they do provide disclosure, but they don't necessarily do it in an understandable way. There's a mountain of legalese documents that's provided, and it's not necessarily clear to the client. That doesn't mean that insurance products are unnecessary. It doesn't mean that insurance salespeople are necessarily unscrupulous or doing anything wrong, but it's the description of how, particularly of how compensation works, that oftentimes clients don't effectively understand. A general summary of the likely conflicts of interest. We can't think of anything that may arise in the future, but what are likely to be some potential conflicts of interest, we need to provide a general summary of that, and we need to let our clients know how those conflicts will be resolved in the event that they come up. Any information that the client would be material to the client's decisions to engage you in how they would manage their own affairs. And then contact information, certainly. And then there's a Form ADV, which is under the Investment Advisors Act of 1940. And then anytime there's some changes, any changes to the situation, the advisor needs to let the clients know when those changes have occurred. So basically, you're not allowed to share information that the client gives you. You except under certain circumstances. When you receive not a request from an attorney, but an order from a court to provide information, let's say a client is going through a divorce or the client is being sued. When you receive a court order, you shall do that. Now, if I need to give it to my employer, and generally the agreement is not just between me personally, but is between my employer and the client, then I need to provide that information. And if the client is suing me, I'm allowed to use that information to defend myself through a legal process. And then, or as needed to perform the services, and we talked about how that might be if I'm going to engage other entities. So we need to protect the security of client information, and this is something that people are worrying more and more about in the digital age. You'll still find plenty of firms that have old-fashioned, very large old-fashioned paper files, but more and more files are electronic. There's tons of client information that is in the cloud. And so it's important that you go through a process, or that the firm goes through a process to make sure that information is encrypted. And then but it's not only that, but you must keep complete records. So there are record-keeping requirements that don't go into very detailed about what that is for the CFP board, but that are fairly detailed from the SEC about this is a large area known as compliance. You have to document all client communications, things like that. Any written, you need to take notes on phone conversations that happen with the clients. Any email communications need to be kept a record of and things like that. So here's a rule. Neither borrower nor lender be. Don't borrow money from your clients and do not lend money from your clients, with the exceptions of an immediate family member, or if the advisor or the client is an institution, basically a bank, that's in the business of lending or borrowing money. And so there's that information. No commingling, so I cannot pool my assets with my clients in the same account, and nor should I commingle my individual client's property with my other individual clients. Lots of times my clients provide me information. They'll provide me actual copies of their wills and their legal documents and their insurance policies, and then they may say, okay, I would like to have that information back, and there are rules about how you have to provide that information back. So here are the obligations to clients, and so this is sort of just a recap of things that have already been said in other areas. Be fair and professional. Here's a rule that you have to follow the rules. The certificate shall be in compliance. You should be reasonable and prudent, exercise reasonable and prudent professional judgment. Make recommendations that are suitable for the clients. That suitable word is not a very strong word, but it is in the client's best interest. A certificate shall provide supervision to any subordinate. So we have to make sure that our subordinates don't have loose lips, that they fully understand the rules about that they must care for client documents and things like that. It's not a defense to say, well, it wasn't me who told people you were my client and shared personal information. It was my employee who's not a CFP certificate, therefore I'm not liable. That's incorrect. You are still liable. That would be a failure to supervise. So it's good practice to make sure that all employees of CFP certificates understand these rules as well. So these are basically institutional requirements. Obligations to employers. So often we can be in situations where our obligation to our employer pays us, they expect us to act as an agent for them. Our client pays us, and what is an agent? An agent means I'm hiring someone to act on my behalf. Well, the client is also paying us, and they're expecting us to act on their behalf. So there are potential situations where there are potential conflicts of interest, and these are the things that need to be disclosed. So my employer, generally companies, large corporations, are in the business of the objective of business is to maximize revenue. So if I work for a brokerage firm and a broker-dealer, and they're primarily in the business of manufacturing financial products, mutual funds, or bringing companies public to the market, but they use their sales force, their advisors, as distribution channels of those products because people make money by selling those products, then that's a potential conflict of interest with my client. So I have to say this is a potential conflict of interest. I have to follow whatever these rules are by my employer, but I will still look at the overall picture for you, my client, and I will resolve that issue and any conflict in your favor. You do need to let your employer know if you have received any revocation or suspension of your right to use the CFP mark. And here are the obligations to the CFP board. Follow all the rules, so abide by all the terms of the agreement with the CFP board, including meeting your continuing education requirements. And then again, in case we didn't say that, you got to follow all the rules again, abide by the terms of all the agreement with the CFP board. Shall meet all requirements, including continuing education requirements, in case we didn't say that earlier. I think those two were a typo. Changes to contact information within 45 days. So if you're in business and you move locations, you need to let the CFP board know. And then you need to let them know of any conviction of any crime except a misdemeanor traffic offense within 10 calendar days. Don't do anything that reflects poorly in the public eye on the CFP board. That's fairly broad, but the CFP board is very interested in maintaining the integrity and the image of the CFP mark, and they enter into lawsuits all the time with firms that they believe are not doing things that are upholding the standards of the CFP mark. Fiduciary requirement. A fiduciary is defined here as one who acts in the utmost good faith in a manner he or she reasonably believes to be in the best interest of the client. That's a fiduciary. In the context of financial planning, the law has often said acts as a prudent expert would act, and then in the best interest. Well, the best interest of that. So here's the thing. When someone comes to you, a financial professional, and asks advice, why would you just ask anyone for advice on anything? Number one, the reason that you ask someone else advice is that you have a reasonable belief that they know more than you know about a particular subject. That may be one reason, particularly if it's somebody you're compensating for their expertise. So we have to have the expertise. So that's one thing. The other thing is advice. What is just the general definition of advice? Well, it is straightforward. What would you do if you were me? Implying you are in my situation with your knowledge and you are me acting in my best interest. So the implication of a fiduciary standard, I think, is implicit in advice, particularly advice from an expert, which this is why you're going to school, is to become a financial expert. So this is the fiduciary requirement. This is slide 32 I referenced earlier. It talks about the obligations to the professionals, employer, to prospective clients, and to existing clients. That's an important slide to study. Okay, now we move on to practice standards. Practice standards are organized according to the 6 steps of the financial planning process. The 100 series is about the first step, is about the standards of establishing the relationship. The 200 series is about gathering data. The 300 series is about analyzing that data. The 400 series is about recommendations. The 500 series is about implementation, and the 600 series is about monitoring. So we're going to get more granular in terms of what is required in the steps of this process. So about establishing the relationship, it's the relationship and the scope of the relationship is mutually defined. This does not mean that it is different with every single client. As a business person, I may say, this is my standard agreement that I'm going to do. But the client has to agree to that. So here's what I want you to do, and so it has to be mutually agreed upon, and then we have an engagement and the client signs it. Gathering client data. So here's some more specific details. You're required to obtain sufficient quantitative information and documents about a client relative to the scope of the engagement before any recommendation is made or implemented. If you are unable to do that, you don't necessarily have to fire the client and say, I can't do that. But if I'm unable to gather enough information in a particular area, I must then at least modify the scope of the engagement to say I cannot provide advice in that area until you provide me additional information. So you should try a few times to get that information and then say, okay, we're going to have to modify the scope of the engagement. Or firing the client is okay too, but you don't have to. By firing the client, I mean sever the engagement because you weren't able to gather that enough information. Analyzing and evaluating the client status. So one of the key things is we gather quantitative information, we gather qualitative information about what their goals are. Then we have to look at the likelihood of reaching the client's stated objectives, both on an as-is basis, and then if we give recommendations, and then reaching those stated objectives. Now, very often, that's reaching the stated objectives, even with advice, are not very likely. So then we have to go sort of back in the step of the process and redefine the goals and objectives to things that are more reasonable and achievable. Stated goals should be specific, measurable, achievable, realistic, and timely. This is not part of the rules, but this is just this is part of what I'm teaching you about the financial planning process. So we have to be achievable. So often we have to come back and reframe the objectives. We make a series of trade-offs in terms of the timing of goals, one goal against another, the cost and quality of goals, saving current lifestyle versus future lifestyle, and things like that. So the 400 series about recommendations, we talk about what is possible, what are the things that we could do, what is recommended, here's what I suggest that you actually do, and then how it's presented. I have to present it as a matter of opinion because it's based upon the analysis that I perform in projections, which are based upon some assumptions, and I don't know with certainty the future outcome. But I believe that this is in your best interest. And so we can't present things as matter of fact and give certainty about the future based upon our recommendation when there can be no certainty about the future. So we have to be clear in how we do that. So these slides just talk about that, and so we have to talk about alternatives, the alternative or alternatives that are selected by the practitioner. And this is just good practice anyway, to identify not everything that you could possibly do. You don't want to go into deep detail about that. Say, these are some things that often people would do in this particular area. Here's the one that I would sort of recommend, but these are also good candidates. And often there might be a reason that the client has not yet discussed or gotten into with you, or that you haven't uncovered yet, why one of the alternatives might be better for the client. So again, talk about the clients. You must avoid presenting opinion as fact. Then there should be a plan to implement the plan. So once we have agreed upon recommendations, I like to develop a tracker to track the implementation over time, and so implementation is a process. The financial plan is no good without implementation. So we have to say who the primary person responsible is, and it's often a coordinated effort. So who's going to follow up when, and you're going to get me this information, and then I'm going to do that. So there's often steps within each recommendation in order to get things done. So implementing the recommendation, we have to be clear about who is the person who is primarily responsible and the timeline for implementation. And then also selecting products and services for implementation. Again, here's an area where there's potential conflict of interest, but as long as that's disclosed earlier in the process, you eliminate a lot of the problems here. And then monitoring, this should be laid out in the initial engagement, but should be reminded at the end of the initial, financial planning engagement, why it's important for you to let me know when things happen. And then also, as you're checking in with clients, you should have regularly scheduled engagements where you check back in with the client to update the financial plan. And it's important to check in and ask open-ended questions about things that have been changed as well. But you do want to let the client know that it's their responsibility to let you know when things change. Okay, moving on from that, here we get into disciplinary rules. We're almost at the end of the chapter. What can the CFP board do to you if you break any of these rules? They can do private censure, which nobody knows about, but that's almost like double secret probation. Public letter of admonition, which can be publishable often on the internet in these days. They can temporarily take away your right to use the CFP mark, or they can permanently take away your right to use the CFP mark. Note here that this is a difference between this SEC, which has the force of law, and the CFP board, which is a voluntary organization. The CFP mark is a voluntary mark. We don't have to get it in order to do business. The CFP board, the SEC is the body that actually grants a license to do business. The SEC, when you break rules, can put you in jail. They can fine you. The CFP board cannot fine you. They cannot put you in jail. So that's something that's important to understand. But here, in order of the slap on the wrist to the most harsh, from least harsh to most harsh, these are the punishments that the CFP board can do to you. Okay, so here we go, checking into who can be a certified financial planner. These are the things that are a list that, no doubt about it, if you do any of those things, you can't hold a CFP mark. If you have a felony conviction for theft, embezzlement, or any financial-based crimes, forget about it. You're not going to be a CFP. You're not going to be able to get licenses either, or you're not going to be able to get a job because there are background checks for financial licenses. Felony conviction for tax fraud, again, that's a financial crime. Revocation of the financial professional license unless the license was administrative in nature. And then felony conviction for murder or rape, felony conviction for any violent crime within the last 5 years. I guess you are allowed to be violent as long as it was, in your past and it wasn't rape or murder. Presumptions list, 2 or more personal bankruptcies. 1 bankruptcy, okay. 2 or more, probably not going to be able to. If they find that out, they're going to say no, but you actually get to go back and appeal that. Revocation or suspension of a non-financial professional license. Suspension of financial professional license unless the suspension is administrative in nature. Felony conviction for nonviolent crimes including perjury within the last 5 years. Felony conviction for violent crimes other than murder or rape that occurred more than 5 years ago. Those are on the presumptions list. If these things happen, they're probably going to block you, but you can appeal, but it has to be something that's on this list in order for it to be appealable. So here's how you appeal. Written petition must be submitted, and then make sure that it's on the presumption list and not on the definitely banned list. Here on slide 46, make sure it's on slide 47. Then you can provide relevant documentation and make an argument to the commission for determination. that's the end of this chapter. That's the chapter for rules. You will be tested on rules by the CFP board. That's why we go over these for us. And I think it's important that you understand the importance to the profession of maintaining high standards of ethics and competence.